want to give an overview to you today about the COVID-19 pandemic protocol in the criminal courts for the Ontario Court of Justice. And it's a fairly complicated topic, and I'd really encourage you to look at the Ontario Court of Justice website because it'll give all the details. But I'm just going to hit some of the highlights here for you so you understand what's going on and what went on as of July 6th as well. So what happened this spring, as you know, obviously the pandemic hit and the courts were really paused in quite a way, the Ontario Court of Justice. So what was happening is between about March 15th and July 6th, all trials were suspended. They were paused. No trials took place in the Ontario Court of Justice. And what happened was they were still trying to move other cases, though. For example, the courts were very concerned about people in custody, waiting for their trials, waiting to plead guilty, bail hearings, so people languishing in the jails. They couldn't have their trials, so that's all been put over. From July 6 on. Those people in custody, bail hearings were still taking place virtually, that is by Zoom or video conference or JVN technology, so a lot of people were getting released more than normal. Guilty pleas were still taking place. Obviously, those people who want to plead guilty needed to get out of custody or get their jail term served, but trials couldn't take place, so that was very, very concerning. Now, for out-of-custody people, that is people who'd been arrested but released on bail conditions, no trials were taking place between March 15th and July 6th. Only urgent guilty pleas were going on initially. I give an example of urgent. There's a limitation period for stream A ignition interlock on DUIs. That was considered urgent, so that was taking place virtually. I can give you other examples, but it was only urgent guilty pleas, and not many matters are urgent, frankly, for a person out of custody, whether they're facing a jail term or not. It could wait. Not much else was going on for those out of custody matters. You couldn't have your trial, but if you hired a lawyer, you could completely do the normal steps in a file. Your matter was going over presumptively, that is automatically 10 weeks from particular dates, and that's all set out on the website. So some cases went over in 2 10-week increments, in fact, to beyond July 6th. Right now, those presumptive automatic adjournments for all matters out of custody matters are continuing up till August 21. That's the new protocol that's going on. So firms, such as ours, we were able to still do all the normal steps in a client's file, get it ready for a plea. In many cases, we were doing out of custody pleas. For example, the court was accepting virtual pleas by teleconference or video conference, that is Zoom or JVN technology, for matters where the person was not facing a jail term. So the client would be on the phone with the lawyer, with the judge at home, clerk, and all done probation, fines, not jail terms though. Now, fortunately, the courts have opened up now in a limited way. That this started on July 6th. And the courts really modernized, by the way, brought in a lot of new technology, brought ourselves in the 21st century. The Ministry of Attorney General is to be commended for that. In about 93 Ontario Court of Justice criminal court offices across the province, courtrooms were renovated for safety, for plexiglass, social distancing, limited number of people in the courtroom. So for each courthouse, we're starting that this has been done. And not every county did it, by the way, but many. We've resumed trials. So trials started up again on July 6th. The problem is, let's just take a couple different courthouses, 3, for example, where we 3 of our offices, for example, Kitchener, London, Windsor. Many trials run every day there, but they only renovated about 2 courtrooms in each place. So there's this delay problem. They can't handle all the work. They have to give priority to in-custody trials. So there's still problems going on. They're slowly going to roll out those renovations. They are doing it fairly safely. It appears that it is pretty safe in the courts. So that's kind of essentially what's going on. We can still do non-urgent or urgent guilty pleas for out-of-custody matters as long as you're not facing a jail term. So that's a lot of cases. Now, bear in mind, 90% at least, if not 95% of criminal cases are guilty pleas, so we can still continue with a lot of those. There's some great deals happening, though. There's no question. You'll hear that in some of my other videos. The Crowns are concerned about delay issues, so they're giving a lot of great deals on everything from DUI, domestic assaults, drug cases that they ordinarily would not give. But now we're giving priority to the in-custody people. These people need their trial. Trials have now resumed, so you can set a trial date, and it's a great time to hire a lawyer right now. There's no question about that. Great time to hire a lawyer for many reasons, and the principal one is a lot of great deals. Your lawyer can get you set up to set a trial date as well. And we don't know for sure, there may be Charter Section 11B delay problems down the road. We don't know if cases are going to get thrown out. But because of this, the Crowns are really coming to grip with their cases. But the other wonderful thing that the courts have done, this virtual technology is wonderful in my mind, and they've done a great job of really modernize our court system, and we're very happy about that. But it's going to take some time. There's a new normal here. The practice of criminal law will never be the same, and we may be left with a lot of virtual reality going forward to a certain extent, if not completely, who knows? Because, for example, you have a right to have a virtual trial even now, which is very interesting, and some of those are going on. And that's going to be a topic of another video, virtual trials as well. So that's basically, in a very condensed nutshell, what's going on in the Ontario Court of Justice. If you want to read through the 50 pages of notices, you should, especially if you're charged, because that'll give you the detail about your particular case.